Hello, my name's John Sutton. I'm one of the criminal law partners at Armstrong Legal. Today we're going to just talk about general prospects or obligations of a witness and what you might expect when coming to court. Now, as a witness, you hold a very important position in the courtroom. It is your story that the magistrate needs to hear to determine whether or not something did or did not happen. As a witness, you have certain obligations on you. The primary one is you must tell the truth. If you're coming to court as a witness for a client of Armstrong Legal, you should be aware that you will be asked some questions before commencing into the body of the evidence. Now, as I say, if you are here as a client or on behalf of a client of Armstrong Legal, the first person to ask you those questions will be the solicitor representing the client. You will need to tell the court your name, your address, your age, and perhaps your occupation. There are some occasions when you don't have to disclose all of that information. By way of an example, an apprehended domestic violence order. If you are the person who needed protection or you are protected by the order, then you might not want to disclose where you live if it's not known to the defendants. Likewise, if you appear as a prosecution witness, the same questions, the same answers will need to be given. You'll only need to answer this type of questions once, that is, before you give what's called your evidence in chief.
So you had a discussion about your concerns?
Yes.
And then you walked into the kitchen, and
Yes.
that's when you first saw the husband of witness 2?
Yes.
And then you've given evidence that he was angry and that he said some words to the effect of "get out of my house, you bitches."
Yep.
And then what did the three of you do? Yourself and witness 2 and witness 3?
We just sort of stood there and let him go for it.
How did you feel at the time?
I was scared.
And what other aspects of his behaviour led you to infer that he was angry?
He had a red face, he was waving his arms around, and he banged his hand on the desk, also on the table. That's why I was scared.
And did anything else happen? Was there any other behaviour of witness 2's husband that led on that night of note?
I just thought he was being really, really threatening.
And did he approach either yourself or witness 2 or witness 3 physically?
Yeah, he punched me.
And when you say he punched you, where did he punch you?
He punched me on my tricep.
And did he punch you with what part of his body?
With his hand. He had a closed fist. He swung his hand around and hit me on the back of the arm.
And what was the effect on you when he hit you on the back of the arm with his fist?
I fell over because I was leaning on the table. I fell over.
We've already spoken to some extent about how you should deliver your evidence, that is, how you answer questions. It's important that you remember you're there to deliver facts. Don't give speeches, don't deliver soliloquies, don't give long terminologies if you don't need to. If you're an expert, well, that's a different thing and you'll be expected to deliver long speeches. Don't embellish your evidence. Just give the facts as they were, as the items occurred, as the events occurred, as things came into play. A simple explanation is all that is required. From time to time, a simple yes or a no may be all that's required. It's important you don't give a long speech. The lawyers are there, the professionals in the form of prosecutors or defence advocates. They will be the people who, at the end of the matter, bring everything together and deliver a speech. Remember, that's not for you. You deliver the facts. The next likely questions you'll be asked is to take you to the time and the date of the incident that it is you're giving evidence about. Now, beyond this point, the evidence that you'll give can't be the subject of this video because it will depend from matter to matter as to what is going to occur. But in evidence in chief, you are simply asked to tell your version of what occurred. You'll be led to some degree, but the person leading you cannot put words in your mouth. So they can't tell you whether you're telling the truth or not. The truth is the important thing here, and it is for you to tell. After evidence in chief, the next phase is called cross-examination. Cross-examination is where the opposing party gets to put their case to you and put alternative propositions to you, including maybe you're mistaken about the evidence you've given.